The topic today is litigation strategy. Let's understand ki why at all there's a topic by the name litigation strategy. Now, the moment we say litigation strategy, जो पहला चीज हमारे mind में आता है is that we need to prepare a strategy so that how can we win the case. I mean, this is the first point which will come in our mind the moment we say litigation strategy. Now, let's cut this particular into two parts. Okay, one, we need to think from first perspective that whether we should suppose what will happen if you go to the litigation. That becomes a litigation strategy from the pre mindset. And suppose if the litigation is already filed, then the second step comes litigation strategy. So today I will be covering what is pre-litigation strategy so that your litigation strategy is already covered, and then there is a smooth flow in your work what you want to do. And then there are cases where it has been filed against you, no doubt you are not aware of it, even though you should be aware of it. I am assuming you are not aware of it. Then what procedure should we do so that we prepare our strategy so that we don't get into this complexities of legal remedies in our court system. Now, just to start with, what exactly we mean about litigation strategy. Now, there are various modes of we doing the cases. One, business cases. Business cases means where there's an agreement, one party has failed to perform or he failed to interpret the terms in the way which it was intended to. Cases are filed. Second, property matters. Third, no doubt IPR matters. Fourth, any other matters which I'm just taking any other matter. It can be consumer also, RERA also, insurance also, and everything. Right now, I'm not talking about criminal. Okay, but assuming also there's a criminal. In criminal, you don't think about what will be coming and not, but I'm just taking one aspect of it, that what if the cases comes to you and what strategy you need to follow. Now, one, there is a pre-litigation strategy. So right now I'm coming that civil part. Now, suppose you are a businessman or a person who is lending the money or a person who is in a service industry or a manufacturing. Suppose you are a part of MSME also. Now, MSME means उद्योग आधार, okay, statutory arbitration हम जिसको बोलते हैं. Now, what do you mean by post-litigation strategy? Now, suppose you are entering into an agreement with B. Now, you are A and B. A means you are in the business of providing hospitality services, right? Now, what happens is that suppose if you provide hospitality services, there is an agreement being entered into with B. Now, if you have a vision and the point that, okay, what are the points which might give me a problem in future, which will, if it happens, it will, kill me and my business, or it will take a huge chunk of money to someone else. If these three questions you are able to prepare in your mind, the first step is to negotiate. Now, the moment I say negotiate, I am not talking about commercial terms, because end of the day, commercial terms are the part the business, business people, they are there, they will do it. Now, the moment they come to us as a lawyer, as a legal in-house counsel or as a counsel, it is our duty to ensure that what's their intention should be covered into. At the same time, we should ensure that whatever we are discussing or negotiating has to be written down in a paper. Now, the moment I say that note down in a paper, it means that everything has to be consensus ad idiom. I mean to say, जो मैंने सोचा वही आपने सोचा है. There should not be any difference between me and you, A and B. The reason is, unless and until you don't reach that consensus, that mindset, you will not be able to prepare any agreement. Drawing an agreement has become the most important, in fact, if you ask me, this is the biggest important step you take in any matter, wherever, assuming also if there is no litigation coming. Because agreement is the place where both the parties are new, both parties, they want business, both the parties are intending to do business, and both the parties are in a happy zone that let's start doing business with each other. Now, the moment I say each other, it means that the business relation is in a procedure to start. Now, remember, if you have a perfect agreement, the moment I'm using the perfect, it doesn't mean perfection. It means whatever you thought of is there in a part of agreement. If you are able to draw your agreement in a manner which covers your plus, his plus, your minus has been taken care, his minus has been taken care, trust me, your litigation, whatever they will be doing, it will come down drastically at a very low level. And the basic point why I am saying you to do that, because your first priority should be agreement drawn in a manner which we both wanted in a very good way, so that even if it is A and B, even if assume something happens, you are in a position to argue what is be about to come. You should anticipate what will come to you against you. The moment you are anticipating, trust me, you have hit the bullseye. you know what will be going happening. आपको पता चल जाना चाहिए कि क्या होने वाला है. So the first step is draw agreement in a very careful manner. The moment I say agreement, it covers everything. Whether it is between third party and you, A and B, consent terms, your agreement for your services, even though if you are providing any loan to the employee, everything means everything. Today, not entering into an agreement is equivalent that you are committing a very huge mistake, and this might lead to a very huge monetary loss to you. I don't want to name any company. What compliance can do to you is the basic example, which I'm pretty much sure you must have read in the news in the last 1 week. I am not comparing compliance with the agreement, but yes, agreement is one of the compliance when you deal with anyone. Now I am coming to the litigation strategy. Now suppose you enter into an agreement, आपका पता चल गया आपको क्या करना है. The moment you enter into an agreement, just ensure that you draw the chart, what you need to do, what is point wise you need to understand, what is the obligation you have to do. Just prepare a chart so that you know what will be going on. I am assuming that you have done everything as per the law. I am pretty much sure that it becomes very difficult in business that you have to comply with all the laws. I am pretty much sure कि ऐसा हो ही नहीं सकता कि आपने पूरे legal या terms को comply किया है. But what I am trying to say, at least comply the basic part of the agreement. You did everything. You did everything. You entered into an agreement. Email conversations were there. No WhatsApp chat was your business call. I mean to say, just avoid doing business in WhatsApp. Don't take any approval through WhatsApp, please. Assuming also that WhatsApp has become the most easy way of doing the business. Even I'm not denying that, but make that as a part of your email. बहुत सिंपल सा चीज है. अगर आपका WhatsApp पे डिस्कशन हो रहा है, आपने ग्रुप बनाया है, राइट, आप स्क्रीनशॉट ले लीजिए और उसको ईमेल पे भेजते रहिए जहां पर भी आपको लगता है कि दिस पर्टिकुलर WhatsApp इज वेरी इंपॉर्टेंट फॉर मी टू इवन गो अहेड. अगर आपका किसी ने कोई प्रपोजल एक्सेप्ट कर दिया या प्रोजेक्ट एक्सेप्ट कर दिया, एंड ट्राई टू मेक इट एज एन ईमेल, बिकॉज इवन इन ईमेल इट इज काउंटेड एज एन एविडेंस इफ यू फाइल 65B एविडेंस, सेक्शन 65B का. डू दैट. आपने ये सब कर लिया. आई एम प्रीटी मच श्योर दैट व्हेनेवर एनी केस इज फाइल्ड, यू डोंट कम अंडर दैट सरप्राइज एलिमेंट कि ये क्या हो गया. You know what will be coming. There might be differences in the way you interpret, the way he interprets. See, interpretation is not a big thing, because when I say when you have done the agreement in a very clear manner, interpretation is not read in one particular isolated part. It is always read when it covers all the terms into one particular part, right? You cannot take one clause and say कि ये मेरे favor में, ये उसके favor में, right? So you comply with everything. The moment you do that, suppose if the litigation is filed, this is where your strategy comes into picture, assuming that you have done the pre-compliance. Now, what has to be your strategy? Strategies बहुत होता है. From a lawyer's perspective, there's a different strategy. From a legal company, from a company which has a legal matter, it has a different legal management strategy. So I'll just try to compare both, and I'll try to discuss both. अगर मैं company wise देखता हूँ, suppose if any company case has been filed against that particular company, the first thing you need to do is that definitely आपके पास समय, you have a limited time to reply. So जिस दिन आपको ये मैटर मिल जाता है, go through the papers without wasting the time. अगर आपका internal legal department, give it to them or give it to someone whom you know or whatever your references are. Speak to them, draw the chart, what they have filed, what they want to do. So the first step which comes for the legal company, company against whom the case is filed is case क्या file हुआ है, and let's take an opinion. एक बार आपने opinion ले लिया, draw the chart, what has happened and not happened, and trust me, don't go by an assumption or presumption. Make it very clear what proof you have or not to have. There might be debate and that what I am showing is not relevant or relevant. हो सके तो give open all your talks with your lawyer so that he is in a position to know what can be given as an evidence and what not. Because sometimes giving evidence of all the documents doesn't make any sense. It has to be very limited, crisp, and related to your matter. It might be possible that you have 100 of emails, but that will not serve your purpose. If the basic part is that if you're able to show only one document, and if that serves your purpose, go for it rather than showing all the 100 emails. So now आपको ये पता चल गया है कि केस कहाँ पे फाइल हुआ है. Take an opinion, draw the chart, what you have made a mistake or not. Now if you do this, now the time comes जहाँ पे you need to find out that what are the chances of we trying to closing the matter in a very good way. Now as a business person, definitely I will say that you try to close the business in a very amicable manner, and as a businessman even you should try. Now there is a mediation act also which has come into picture earlier and also right present there is an arbitration conciliation act. Just try to see कि आप इसमें settlement कर सकते हो हो क्या। आप सेटलमेंट तब करोगे जब आपको ट्रांजेक्शन पता होगा ना। बहुत समय ऐसे हो जाता है कि कंपनीज, आई हैव सीन मोस्ट ऑफ द एमएसएमईज इज दैट मैटर आने के बाद दे गिव इट टू देयर स्टाफ, दे से कि आप देखते रहना, एंड बाय द टाइम ही थिंक्स ऑफ, आपका टाइम चले जाता है और यू लूज दैट पर्टिकुलर मोमेंटम आल्सो टू टेक इट फॉरवर्ड। गिव इट अ प्रायोरिटी ऑन ऑल द लीगल मैटर्स व्हेन इट कम्स टू यू। तो अच्छा है या बुरा है, प्लीज यू डोंट डिसाइड, लेट योर लॉयर डिसाइड। इफ यू फील दैट नहीं आपको एक और ओपिनियन चाहिए, गो फॉर द सेकंड ओपिनियन। इन फैक्ट आई थिंक देयर इज अ प्रोविजन अंडर परामर्श करके है, देयर इज एन ऑर्गेनाइजेशन हु हैज दिस परामर्श करके, आई थिंक इट्स अ टीपीएफ, वेयर दे गिव द सेकंड ओपिनियन, ट्राई फॉर दैट, if at all you feel so. Now the point comes is that आपका स्ट्रेटेजी किस तरीके से होना चाहिए। The moment आपके हाथ पे सूट आता है और केसेस आता है, just go through all your cases, just mark the relevant point what it comes. Now the question comes, in which court the matter is all about. Now suppose if it is a high court or district court, it doesn't make any differences, but the only point is that you need to appoint a lawyer, or if you have a lawyer, that he should be aware of the compliances of the high court or a district court. Number one, it is not a very big thing, but you should know. End of the day, I'm telling you, drafting a reply or a written statement is one of the most important criteria even for you to taking your matter forward. Even drafting a complaint also, please don't take drafting as a very lenient way. No, please don't do that. एक drafting होता है जहाँ पे you have to use your mind in 100% assurance. Drafting is such important that if you miss any point, and if you try to mislead anyone, and if you try to play game, you will be catch. You will be caught. I'm telling you. मालूम पड़ जाता है. So drafting becomes the most important part. So now the question comes कि आप draft कैसे करोगे? Well, I will take another lecture if you want कि drafting कैसे किया जाता है. But just to cover up, try to make your drafting very simple, very crisp. What are your issues? आपको उसे क्या claim करना है? Try to see that you don't make partial pleadings. Make it full pleading. आप pleading पूरा कर लीजिए. अगर मान लीजिए आपको किसी से पैसा लेना हो 2 इनवॉइस का, आप वो 2 इनवॉइस के बारे में मत बताइए, उसके पहले का 10 इनवॉइस बता दीजिए। इनवॉइस ले लीजिए, ईबे चालान बिल ले लीजिए, अगर आपका लेजर है तो लेजर ले लीजिए, बैंक स्टेटमेंट ले लीजिए। द रीजन इज बिकॉज ये सब बताने के बाद आई एम प्रीटी मच श्योर दैट यू हैव ऑलरेडी कवर्ड योर बेसिस वेरी क्लियर, सेइंग दैट आई वाज ऑलरेडी इन रिलेशनशिप, नाउ आई एम इन रिलेशनशिप, नाउ ही हैज नॉट मेड द पेमेंट, अर्लियर he made the payment, he has accepted the way I used to deal with him, there is nothing new in this matter. So this is the way you cut short your matter, and the opposite party, he doesn't get the chance even to take it forward. And I am pretty much sure if your reading and your documentation, your drafting is almost near to very good, or I can say perfect, there will be a settlement 100% for sure. Now most of the cases are being defended because pleadings are not good or evidences are not being filed as it is required to be filed under the law, evidence law. अगर आप ये चीज को ध्यान रखोगे तो अच्छा है. Now how the strategies can be formed? Strategies are always formed when you know what is the matter, what they are claiming, how many proof you have to defend your claim. Now it is one thing that you know everything that you will win the matter. It is a different thing that you know you have everything but when to win the matter. And the third part, you know that you are in a very safe position. So now the question goes, when to hit them. Now this is a strategy a very good lawyer will prepare. Now I am taking one example. Normally what happens in I have seen that when you file 138 case, I have seen that company, they file the case without appointing anyone. Okay, they appoint someone as an authorization person. They give even board resolution nowadays, because I'm assuming that everyone who is is here, they know that if you want to file a case, you need to pass a board resolution. You pass a board resolution and then you appoint someone and you file the case. Now suppose if the opposite party is a private limited, I have seen that you file a case against private limited but you don't name the person who has signed the check. If that is the case, so now the question comes, as an opposite accused lawyer, should you appear in summons and lead the trial, or no, you directly approach the relevant court and get the matter dismissed. Now this is a pure strategy which is formed, which is an internal call. I cannot go it in detail how and why. Someone might feel कि नहीं मैं पूरा evidence लड़ने वाला हूँ and then I will prove my case. Second, no, I will cut short the matter here. I will go to the appeal court or wherever the court is and I will discharge this matter. Now I'm just telling one scenario how this strategy sometimes go against you and in your favor. Now suppose the person who has filed a case against you has got 2 checks. He has filed a case against you in one of the check, right? And what happens is that particular check, if whatever 138 has been filed, suppose if you go to the higher court and get this matter dismissed, definitely after your dismissal, he will get the information that why this matter has been dismissed. So he will not do the same mistake in your second check. So basically what you did, you gave him a way how you should file a case against me. Just think whether it is good or bad. Now, this is where your smartness has to come into picture. In fact, you should know what the opposite party has, what the opposite party wants, and accordingly you should draw the strategy. Now, if you ask me what I will do, that I will draft, I will definitely not go for the discharge of this matter. I will stand in trial. I will try to ask him कि आपके पास कोई और check है, वो check किधर है, क्या है, and then I will go for the evidence and I will get this matter in my favor. By the time I do that, I am pretty much sure कि कम से कम I am assuming a minimum average time for any 130 it also goes for 1.5 years. 2 साल. I will try to put that another check also to the part of this particular case, and then I will try to win the matter. Now, suppose if I am able to do that, what I have done, I have already covered both the checks in my matter. In a way, I have stopped him to file another case under 138. Now, there might be a question कि मुझे कोई रोक नहीं सकता 138 फाइल करने से. Now, there is a different call. I don't know वो कैसे फाइल करेगा, क्यों फाइल करेगा. But I am pretty much sure as an accused, I have played a very smart and safe game that I have done the justice for all the two matters. And this is where your strategy comes into picture. So strategy has to be made based on your case. What is the case? What the opposite party wants? What the opposite party has? What is the situation of the opposite party as of now? At the time when he filed the cases, what he wants, what can be waived off, what I can waive off, what I cannot waive off, what I can give, what I should not give, what is my strategy, whether can I make the payment, whether should I receive the payment in partial or parts, should I go further and settle the matter. ये जो पूरा का पूरा question what I said ना, it is purely based on what the matter is all about. Trust me, you not following a strategy might kill the matter 100%, because if you don't follow, if you don't have this particular strategy of doing the case, what will happen is that you, suppose if there are 3 cases, you might win 1 case, but that another 2 case will be a problem for you. So play your cards very well, because now the moment I say litigation strategy, it means that now you are before the court. Don't take it lightly. Court goes by the law. What is there, A and B? And law is huge. If you think this is definite, he will try to prove this is infinite. पूरा game इसी पे होता है. You know, there are 100% of cases, 50-50% दोनों के पास है. Who is able to prove 1% more, 51%, he takes the matter in that favor. Right? It can be anything. It can be technical. It can be your non-compliance of law. You know, even not paying appropriate court fees is a technical law, but you will win the matter. Strategy. When to hit the strategy is a strategy. When to keep the strategy hidden and not is a strategy. ये पूरा एक litigation strategy का gamut होता है. Now you might be thinking कि you know I have been speaking about strategies and but इसको work कैसे करना है. बहुत simple है, बहुत simple है. अगर आपके पास कोई case file होता है ना, आप सिर्फ पढ़िए और आप उसमें से relevant points निकालिए. Make a synopsis out of it. Just make a synopsis date wise. ये date को ये हुआ था. Now compare that date with your events and just situate where your case matches. So I'm taking 2 assumptions. You have a very good proof to prove कि I will able to match them because I have a very good proof. Second, nahi, whatever they have stated is true. Now what to do? I'm going by the first one as of now, and then I'll come to the second part. Suppose if you have a good case, make a synopsis. आप अपना synopsis बनाइए, match it, and then that particular time you decide how to draft a reply. Is it necessary for me to put everything on record on WS, or should I keep something for my evidence? Even that is a part of the strategy. Now, whether to put or not put, it depends on what the opposite party is claiming against you. If you feel by putting this, it will take my matter further, go for it. Sometimes it does kill your matter. If you feel me putting right now, it doesn't make any purpose, but I will do it in the later stage, do it. But then draft your written statement or statement of defense in such a manner that neither you are telling them what I want, but at the same time, you are telling them I will go for it. This is where drafting comes into picture. Drafting बहुत important हो जाता है. It is not that easy, nor it is difficult. Don't try to use very difficult, complex word. Make it very simple so that you know हमें तो समझ में आ जाए क्या लिखा हुआ है. So now I'll go to the second step. मान लीजिए as an accused you don't have any defense. You don't have any defense. You know the person who has filed a case, he has filed a case in a very perfect manner. Now, as an accused, you don't have any other defense. Now, बहुत सारे time पे क्या होता है when you don't have any defense, you at the first time you try to inform the court that I want to settle the matter by mediation. Mediation में definitely you will try to make the payment if you feel so you have to make the payment and close the matter. But suppose you don't have money. Suppose you feel no, I need to extend the time. Suppose you feel that no, अभी मैं payment नहीं करता हूँ, we'll see what happens later. Even though if you ask me ethically, you should not do that. But as a legal part, it might happen that a layman doesn't know what defense you as a lawyer can come out. It can be a technical defense also. You know, if you don't put verification under section 138, it can also lead to a dismissal of that particular complaint. Even that has a very relevant part. If a summons is issued under 138, and if the accused are abroad, they are not from your area, if that summons is not issued as per the compliance of inquiry, you know that even that summons is invalid. So take the help of the lawyer. If a lawyer is aware of such little bit of technicalities, make that as a strategy and make this as a defense. So your defense has to be, it should be defined in a way that what you want, whether you want to close or whether you want to delay. Trust me, delay ethically doesn't make any sense. You should never delay the matter. But it is totally depends upon a particular person when what they want. So I'm not the right person to comment आपको क्या करना चाहिए. But yes, as a lawyer, if you come to me, if I feel that we have a matter to fight for, go for. But make a strategy. ये सब तो आपने कर लिया, आपने understand भी कर लिया, सब कर लिया. Now the basic comes is cost. You need to appoint a lawyer where your budget fits into that particular matter. Now, that's what I'm saying, rather than you waiting for the case to be filed and then think of the cost, well, you don't have in your hand kya hone wala hai. But then why don't you have pre-litigation strategy in such a manner that you are aware ki ye hoga to ye bhi hone wala hai. Okay, I'm just mentioning 2-3 clauses which might give an impression that how the agreement works to save your litigation cost. Now there is an invoice statement agreement clause where you say that the invoice shall be raised within 15 days and the payment has to be made within 7 days. This is a very simple clause. मैंने stop कर दिया. That's it. Payment आया नहीं. And there is no indemnity clause. Now, even though there is no indemnity clause, but I can claim my money. So what is happening? I have an option to file a case. But what I have done, if I would have made my agreement in such a manner where I have put an penalty clause and indemnity, I would have saved my time in the litigation cost. Trust me, most of the money, as a litigation cost when you cover, if you are able to complete a matter within quick time, within a very lower period of time, then you save your money a lot. Trust me. But what we do, if you don't give importance to your agreement or the way you draft an agreement, you are only delaying your litigation part. Litigation costs have become a huge cost nowadays. And sometimes I feel that even many of them, they put litigation costs at the end, जब आएगा तब देखेंगे. What I'm trying to say, rather you make a pre-litigation strategy in such a manner that you have all the proofs in your hand. You might have seen the way bank works or you might have seen an NBFC works. Now, I'm just setting an example. Whether it is right or wrong is a different part. You sign an agreement with an NBFC, I'm 100% sure that year whoever is present, 51, none of them must have read what terms NBFC standard agreement contains. No one, trust me. Now there is a judgment also, even though it is an one-sided agreement, the moment you sign, it is binding. अभी क्या होता है, मैं धंधा करने बैठा, मुझे पैसा चाहिए, मैं पढ़ने जाऊंगा, वो तो चेंज करने से रहे, सो मैं तो साइन कर रहा हूँ. मेरे साइन होने के बाद मैं ये प्ली उठाता हूँ कि वो स्टैंडर्ड अग्रीमेंट था, नहीं चलेगा. वो अलग बात है कि कंज्यूमर में बिल्डर वन साइडेड नहीं बना सकता है, बट बैंक वाले जो वन साइडेड बनाते हैं उसको हमने लीगल मान्यता दे दी है. सो व्हाट यू डू, एक्सेप्ट इट. ना उसके भी प्लस माइनस है. If this is the where even I take a pause and say कि law has to come into picture that even the bank should allow a fair clause to everyone. But as of now वो होता नहीं है. Okay, बैंक वाला डाल देता है arbitration चेन्नई में. You take the loan in Bombay, you have to go to file a case in Chennai because उनको मालूम है कि बंदा बॉम्बे से चेन्नई आएगा ही नहीं. और चेन्नई में वो कौन सा बंदा है जो आर्बिट्रेटर बना है वो आपको पता ही नहीं चलता जब तक अवार्ड नहीं आ जाता है. Just think of that part. Just think. इसके लिए you should be very well aware कि आप कर क्या रहे हो, आपको करना क्या नहीं चाहिए. Strategy can also be formed in a manner. Assuming कि वो standard agreement है, assuming you cannot change, you don't have the guts to change, or I will not say guts, but you don't have any role even to play with the changing of the terms. वो मुझे तो धंधा करना है. At least show to the lawyer, he will guide you कि ये सब compliance है जो आपको याद रखना क्या करना. Because by the time when you are not able to make the payment to the bank, you are very well aware कि क्या होने वाला है और क्या हो सकता है. Let not that come as a surprise to you. ये आपने pre litigation कर दिया, litigation strategy में आप opposite party हो तो आपने ये कर दिया. बहुत सारे एक्सपेंसेस भी आ जाते हैं इसमें, जैसे कि लॉयर्स का एक्सपेंस आ जाता है. समटाइम इफ यू हायर अ काउंसिल इन हाई कोर्ट, काउंसिल का एक्सपेंसेस आ जाता है. व्हेन यू हायर, इफ यू हैव एन इन हाउस काउंसिल, नो डाउट ही विल प्रिपेयर एवरीथिंग एंड देन यू हायर सम अदर पार्ट. Now, whether to have a counsel or in-house counsel or the law firm or an advocate, it depends on your budget. It depends on the way you take your matter. But that's my personal opinion that what A can do, even B can do, even C can do. You just have to identify the best person. The moment I say A, B, C, even C can be the best than A. It actually depends on your strategy, how it works out. लिटिगेशन स्ट्रेटेजी में एक सबसे इंपॉर्टेंट पॉइंट आ जाता है कि आप जब ड्राफ्ट करते हो, व्हेन यू पुट डाउन दैट पर्टिकुलर पार्ट, दैट आपका प्रेयर क्या होगा. दिस इज वेयर द मोस्ट इंपॉर्टेंट पार्ट कम्स. बिकॉज व्हाट आई हैव सीन इज दैट जब आप प्रेयर मांगते हो, नो वन गिव्स थॉट कि हम मांग क्या रहे हैं. नो, दिस इज वेयर इवन योर स्ट्रेटेजी कम्स, इट ब्रेक्स डाउन एक्चुअली. प्रेयर को क्या मांगना है, कितना इंटरेस्ट मांगना है. How many of you know that even there is a provision of interest in negotiable instrument act? Just see, there are two clauses which has been defined. Just read that particular clause. Even they give 18%. Just imagine. I mean, the law has covered everything. It's all about we to make a strategy. How we can make the strategy. I'm just giving you one example. One more example how the business entities they can save. Now बहुत सारे ऐसे लोग होते हैं जहाँ पे दे से कि हम परचेस ऑर्डर नहीं देते, हम अग्रीमेंट नहीं करते. We don't have anything in writing, and MSME that doesn't allow if we don't have a purchase order. What you can do, I'm just giving you one tip. Take this as a tip. आप एक क्या करो, आप कोटेशन बना लो. कोटेशन. So what happens? Suppose if I want to buy a CCTV, I will tell someone कि आप मुझे कोटेशन दो. So that person he will send me a quotation. So that becomes an offer to me. It's an invitation to offer, right? आपके कोटेशन में टर्म्स क्या होने चाहिए कि once this quotation has been accepted, okay, it shall be taken as a purchase order. खत्म कर दो. Now suppose if the opposite party raise a purchase order, okay, purchase order में कोई terms होगा नहीं, उसमें अगर कोई भी term नहीं है, you don't do anything, right? आप purchase order में एक ही line डालना that terms as stated in the quotation shall also be the part of purchase order. Then आप invoice पे चले जाओ. Invoice में when you say reference, use purchase order and quotation. So this is where even your offer, invitation to offer can become an offer if you are able to match with your PO. I'm not saying this will give you 100% assurance कि सब जगह होगा, but this is the way you need to play your game. Actually मैं business में हूँ, so this is the way strategy works actually. Now I'm coming to the main ingredient of the legal strategy. The moment I say litigation strategy में आपका monitoring भी आ जाता है, the way you file a case, how to file a case, इसके ingredients भी ऐसे ही है कि आप सोल प्रोप्राइटर हो तो डेफिनेटली आप खुद फाइल करो या तो पावर ऑफ अटॉर्नी दे दो. पार्टनरशिप हो तो डेफिनेटली आप पावर ऑफ अटॉर्नी दे दो, बिकॉज इवन द लेटर ऑफ अथॉरिटी वर्क्स आउट. बट ट्रस्ट मी, where there is an interpretation is better to give power of attorney, because somewhere I feel that letter of authority can be challenged in a very good way, because there are sections under Indian Partnership Act कि एक पार्टनर को पता नहीं था दूसरे पार्टनर ने क्या किया है. सो बेटर यू टेक पावर ऑफ अटॉर्नी एंड यू बी फ्री फ्रॉम दैट एस्पेक्ट. एज अ कंपनी डेफिनेटली यू विल गो फॉर अ बोर्ड रेजोल्यूशन एंड एवरीथिंग. स्ट्रेटेजी वाइज मान लीजिए अगर आपको क्रॉस करना हो, सो आप पूछ सकते हो कि बीआर का मिनट्स ऑफ मीटिंग किधर. सो नाउ आई एम कमिंग टू द मोस्ट इंपॉर्टेंट पार्ट लिटिगेशन स्ट्रेटेजी में, दैट व्हाट डॉक्यूमेंट्स टू एडमिट, what not to admit, what to inspect, what not to inspect, issues to be framed और cross. ये जो litigation है, I'm definitely sure कि बहुत सारे lawyers हैं उनको पता है what I am saying. This is a procedure we need to follow. CPC का procedure क्या है? I will just brief it. You file a pleadings, opposite party will file a written statement. ठीक है? If you have a counter claim, you file it, then plaintiff will file the reply. एक set done, then the issues will be framed. Then definitely trial stage starts. Evidences are being filed. You file an evidence, opposite party will take the cross. Before that, if you feel, you can take an inspection if you feel so. ठीक है, आपने केस फाइल कर, अपने एविडेंस फाइल कर दिया, then there is an admission of liability and the admission of documents and denial of documents. What to admit and not to admit itself is a strategy part. You should not admit if you feel you can get it denied. Please don't take it as a very routine way, because एक बार आपने admit कर दिया, then you are losing asking any question even in cross, because you've admitted those documents. Admissible documents को आप क्या cross लोगे? You have already admitted the document. So what to admit and not to admit, what to deny and not to deny is a strategy. I have seen many people एक letter दे देते हैं, लिख देते हैं deny, 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 deny. Well, if you feel that is a strategy, it might work out, that's your choice. But most of the time it doesn't work out that way. What we are doing, we are just giving an impression कि मैं तो सब जगह cross लेने हूँ. This is what I have seen in most of the matters. Admitting a document and denying a document is a part of the strategy, and this should not be taken very lenient. It has to be very mindful. Issues framed shall match with your admission and denial. It should. Both should come in such a way that whatever you are admitting and denying, it doesn't contradict the issues framed. एक बार आपने वो कर दिया. Now this is where the cross starts. Cross is one of the most important way to break the defense If you are an opposite party, you want to break the defense. If you are the first party, you don't want them to break the defense. तो ये जो breaking of defense होता है ना, ये cross में ही होता है. और ये cross आप कैसे करोगे? If you are not aware of your papers, if you are not aware of the matters, if you appoint someone who is not aware of the matter, if you appoint someone who doesn't know what the matter is, and you appoint someone जिसका यही काम है. I have seen in cases where one person he appears in the court for 40 matters. Everywhere he gives a very standard line. I will just repeat 3 questions and see his answer. मैंने एक मैटर्स में ऐसे ही पूछा था कि आप कितने मैटर में अपेयर होते हो? 40. मैंने सभी मैटर में एक ही ट्रांजेक्शन होता है? बोलता है हाँ. मैंने पूछा आपके सभी एग्रीमेंट में सबसे क्लॉज सेम है? बोलता है हाँ. बोला आपके इनवॉइस में सब जगह 45 डेज लिखा है? उसने बोला हाँ. तो मैंने उसको कहा कि यही मैटर में 30 डेज कैसे आया? बोलता है मुझे पता ही नहीं. हाँ खत्म. You gave the defense. You gave the defense now because you are appointing someone. He doesn't know about the matter of that particular matter, but what he knows is about 40 matters. So आप किसको अपॉइंट करते हो, नहीं करते हो, what he wants to say is a part of strategy. Now क्रॉस में खड़े होकर आंसर देना is not that easy, neither it can be more difficult. Now I don't know what is the practice, but I will tell you the way it works out. You know the matter what has been filed, assuming that you have not followed the pre-litigation. You know what the matter has been filed, you know what the written statement has been filed, you should know when the objection should be filed, everything said and done, issues are framed, you admitted, you denied documents. Now they have filed an evidence. Your first motive should be that I don't want my client as a defendant to appear as an evidential witness. Try to complete the matter before he even goes to the court. How you can do that? You should play the smart with the way you take the cross. The biggest strategy, if there is 100% of strategy to be required, I will take, if you are a pre-litigation person, I will say 60% of the strategies goes to that part. But if you are not, you have to give at least 75% to the cross. If you don't do that, you will lose the matter. What question to be asked, what not to be asked. हमें बहुत टाइम ऐसे लगता है कि रिकवरी का मैटर है, बहुत सिंपल है, क्रॉस पूछ लो हो जाएगा. It doesn't work that way. Even the simple recovery matters can give you a googly in cross. Example देता हूँ मैं आपको, बहुत सिंपल सा चीज है. मेरा प्लीडिंग ऐसे था कि मैंने इसको माल बेचा, ईबे बिल है, 72 आवर्स का टाइम है, मैंने माल दिया, उसने मुझे पैसा नहीं दिया, मैंने केस फाइल कर दिया. बोलने में बहुत सिंपल है. सो बाजू व्हेन वी फाइल अ केस वी फील कि बाजू वाला क्या ही क्रॉस लेगा, क्या ही लेगा. Now, I don't know who has appeared as a person, but I'm assuming that someone who is aware of this matter, he has appeared. See how the opposite party can break your defense. He will ask you कि आपने ये माल जो दिया था वो माल क्या था? ये माल आपने जो डिलीवरी किया था क्या ये ऑर्डर के हिसाब से था, परचेस ऑर्डर था? अज्यूमिंग एवरीथिंग वाज हाँ, सब था. He will say कि आपने जो इनवॉइस रेस किया वो अपने माल के बाद दिया क्या पहले दिया? अच्छा आपको पता है कि मैंने डिफेक्ट रेस किया था, आपको ये पता है कि जो माल आपने दिया था वो मैंने कभी एक्सेप्ट नहीं किया था, वो मैंने आपको ऑलरेडी इन्फॉर्म किया था. कि ये सब जो क्वेश्चंस आएगा ना, which you thought will never come because EV bill is there, then you are wrong. EV bill is there is very good. 72 hours का GST का परफेक्शन है कि होगा, but will that guarantees कि आपने माल दिया था? If you think so, no, you are not. If you don't think so, you might be right, but opposite party has a chance. So आप क्या क्वेश्चन पूछोगे, क्या नहीं पूछोगे, it has a very big relevance with what you think when you drafted the suit. So जब आप suit draft करते हो as the pleader or as a written statement, you should draft in a manner that आपका जब क्रॉस आएगा, you should match it. ऐसा नहीं कि पहले आपने ड्राफ्ट कर दिया, एविडेंस दे दिया, क्रॉस में ले लूंगा, ऐसे नहीं होता है. Suppose if there are 5 steps, 5 steps. All 5 steps has to start with 1 step. एक होगा मुझे 2 के हिसाब से चलना है, 5 आने वाले. Now how CPC का स्टेप क्या होता है? रीडिंग फाइल किया, रिटर्न स्टेटमेंट हुआ, काउंटर क्लेम हुआ, रिप्लाई फाइल हुआ, इश्यूज फ्रेम हुआ, एविडेंस हुआ, क्रॉस हुआ, ऑपोजिट पार्टी का एविडेंस हुआ, क्रॉस हुआ, आर्ग्यूमेंट हुआ, जजमेंट हो गया. वेरी शॉर्ट, but this takes good years nowadays. But go with the strategy. अगर आपने जिस दिन ड्राफ्ट किया उसी दिन अगर आप उसको स्ट्रेटेजी में डाल दोगे कि ना दिस इज द वे आई नीड टू पुट इट, दिस इज द वे आई शुड पुट इट, ट्रस्ट मी आपके बहुत सारे मैटर्स ऐसे ही अच्छे से क्लोज हो जाएंगे, अच्छे से. नाउ आई एम कमिंग टू दैट पर्टिकुलर पार्ट. ओके, आई जस्ट कवर दैट क्रिमिनल का पार्ट आल्सो. आई हैव स्पोक अबाउट सिविल की किस तरह से स्ट्रेटेजी बना सकते हो. कभी कभी यू शुड नो द बैकग्राउंड ऑफ द ऑपोजिट पार्टी, बट हो सके अगर आपका अग्रीमेंट सब बराबर है, ऑपोजिट पार्टी के साथ आपका अग्रीमेंट हो चुका है, देन डेफिनेटली यू शुड background becomes your very easy कि आप background करोगे. Now see how strategy works out. At the time when you enter into an agreement, as I'm assuming, why don't you take a KYC? Practically I know business करना है तो आप इतना सारा information नहीं लेते हो. कभी तो ले लो. अगर आप मान लीजिए कल को पैसे भी लेने हैं आपको उनसे, आप कोर्ट भी चले गए, आप मैटर भी जीत गए, आप उसका कौन सा एसेट को अटैच करवाओगे? So your strategy starts when you start dealing with the customer, you start dealing with that person. Opposite party, if he's smart enough, वो समझ जाएगा कि मैं इसको सब दे दूंगा तो प्रॉब्लम आएगा, तो वो पहले ही नहीं बताता है. So he has already started his strategy. So even you start your strategy. Every information जितना आपके पास होगा उतना आपके लिए अच्छा है. So that will clear cut reduce your litigation in a very minus time. If you go to arbitration, well, no doubt arbitration is the best way to resolve the matters, but somehow my personal view is that it has started becoming too costly now. I mean to say, I don't know if 2 years back arbitration for me was very good. Now it has started becoming too costly. So एक बिजनेसमैन ये सोचता है कि आर्बिट्रेशन में जब इतने ही पैसे देने हैं तो मैं कोर्ट क्यों नहीं चले जाऊं, भले वहां पे 3 साल जाता है. सो कौन से मैटर को आर्बिट्रेशन में डालना है नहीं डालना है, अगेन दैट हैज बिकम अ न्यू स्ट्रेटेजी इन योर बिजनेस एनवायरनमेंट, इन योर वे ऑफ डीलिंग द मैटर्स. पहले लोग कॉपी पेस्ट करते थे आर्बिट्रेशन का क्लॉज. नाउ थोड़ा आप पॉज रखो, डोंट कॉपी पेस्ट, just think whether this arbitration is enough good for you for monetary wise. I have seen arbitration centers जहाँ पे 2-3 लाख रुपया लिया जा रहा है, and personally I feel it might be very costly for even for your clients. So even that becomes a part of strategy. If you are an opposite party, think. If you are a first party, think arbitration का clause कब आना चाहिए और नहीं आना चाहिए. If you have a background of the opposite party, you are in a very good position to understand कि मैं उसको कब पकड़ सकता हूँ नहीं पकड़ सकता हूँ. Now I'm just telling you one more strategy part when it comes to litigation actually. सबसे बड़ा point आता है time. Many of them have the same concern कि कितना time जाएगा. So legal remedies come into picture, right? Now legal remedies तो बहुत है. Recovery के लिए आप summary suit है. आजकल तो commercial court आ गया है. Then there's a civil suit, right? Then there's a commercial summary suit. Then there's an NCLT. NCLT is not a recovery forum, but many of the cases are being filed for recovery only. And then there is a 138. अभी आप strategy कैसे करते हो? Just imagine that you have a check of 50 lakhs. You are not aware of the opposite party, but आपको पता है उसके पास पैसे हैं. So now the question comes, should you file only 138 or you should file summary suit also? Or should you file not summary suit but NCLT also? What cases you should file it? Definitely 1 करोड़ के नीचे है तो आप NCLT जा ही नहीं सकते. So I'm taking a scenario जहाँ पे वो 1 करोड़ के ऊपर है. Now the question comes, should I file NCLT also or 138 also? Or only 138 or NCLT? So again, this becomes a part of strategy. So think wisely. Even NCLT says that 138 against the directors can go, not against the company, right? Suppose if I go to NCLT and if I file 138, you should know opposite party का situation क्या है. Just because you have an option and you fight, don't do that. Just think. अगर आपने 138 फाइल किया, मान लीजिए 138 फाइल किया, should you go to NCLT? It depends कि उस टाइम का सिचुएशन क्या. अगर वो कंपनी बंद होने के कगार पर है, go and file it NCLT. आई मीन से कोई पर्पस तो आपका वैसे सॉल्व नहीं होने वाला है, बिकॉज NCLT में तो आप in fact, you going and filing the case are treated as a god for other persons who wants to recover the money, because वो आपके खर्चे पे डेबिट क्लेम कर लेते हैं. So you play the smart game कि भाई मैं जाऊँ या नहीं जाऊँ. So it totally depends on that particular customer, on that transaction, whether to go or not. Because आजकल एक कोड लगा हुआ है, 1 करोड़ के ऊपर है तो NCLT जाओ, नहीं है तो एक काम करो, दूसरा केस करो. आई एम नॉट सेइंग इट इज रॉन्ग और नॉट रॉन्ग. व्हाट आई एम सेइंग, स्ट्रेटेजी यूज करो, बी वाइज. बिकॉज ऐसा तो नहीं कि आप 2 केस करोगे, सब पैसा झोंक दोगे, फिर बचा गया. एंड ऑफ द डे फ्रॉम द बिजनेस पॉइंट ऑफ व्यू, 1 करोड़ के क्लेम में इफ यू आर स्पेंडिंग 15 to 20 lakhs and even if you incur 80 lakhs, you might get the order. Now the question comes कि आप उसको रिकवर कैसे करोगे. अगेन इफ यू आर स्पेंडिंग उसमें 5 लाख, 1 करोड़ में 25 लाख आपका वेस्ट हो रहा है, राइट? आई डोंट नो व्हाट इज योर प्रॉफिट मार्जिन, बट आई एम अज्यूमिंग इवन 10%. 1 करोड़ का 10% इज 10 lakhs. आपने ऑलरेडी 25 लाख डाल दिए, पैसा आ रहा किधर है? What I'm trying to say कि थोड़ा स्ट्रेटेजी बनाओ, right? Understand what is the opposite party background. उसके लिए what you can do. आप जैसे डीलिंग करते हो ना, every 3 months check about your customer, opposite party कि वो क्या कर रहा है नहीं कर रहा है. Make a chart, understand their background, the way they work, not work. आपको एक अंदाजा आ जाएगा. Should I file case now? Both. क्या एक, कौन सा, कहाँ. There is one more strategy which is being used nowadays is that कि आप क्या करते हो, आप चेक ले लेते हो, आपके पास 3 ऑफिस है, आपका 3 ऑफिस है ऑल ओवर इंडिया में, तो आप क्या करते हो, वो बॉम्बे करेगा तो यू फाइल अ केस अगेंस्ट इन चेन्नई. लीगली इट इज नॉट रॉन्ग. Again, that becomes the part of strategy. I have seen many banks they're doing it. You take a loan from Bombay, but case 132 के अहमदाबाद में होता है, arbitration चेन्नई में होता है. If you ask about the law, law is silent on that part. They say cause of action. उनके लिए cause of action वहां पर हो गया है. If you say that is illegal, for them it's a strategy to recover the money. For you it is not correct. For them it is as per the law. So basically, even they play the strategy. You start playing the strategy. All in all, litigation strategy बहुत easy हो जाता है if your first step when you took, if you anticipate कि क्या हो सकता है और क्या नहीं हो सकता है. Now suppose litigation file हो गया. So now the question comes, should you stick to that code or you should not try another remedies? Go for it. End of the day, what we want from the court is what we went to the court. उसके लिए go to the court, try other amicable ways. Amicable means what the law says. Not, I'm not saying any other than law, what the law says. Please for God's sake don't hire if you want to recover recovery agents and everything, वो आपके ऊपर against आ जाएगा. So strategy, if the word is used with litigation strategy doesn't mean कि आपका strategy सिर्फ litigation से होना चाहिए. That litigation strategy it includes कि आप ऐसा कुछ करो कि आपको litigation का strategy कम यूज करना पड़े. अगर आप कर ही नहीं रहे हो तो वो strategy definitely पड़ेगा. और आपको ऐसे strategy form करना है कि जहाँ पे you are able to save the money, that becomes your best strategy. So best strategy क्या हुआ? Enter into an agreement where even if you spend 10 rupees more, go for it rather than spending 100 rupees later, because that time you are not sure what will happen. I will just give one example that you are dealing with someone. Suppose okay, you are dealing with someone जहाँ पे limitation of liability का clause है आपके agreement में. And that I'll rephrase the question. Suppose if you go to any website and you want to order something, and you have ordered something, you have never read the agreement, और जो आपने order किया वो आता नहीं है, और it doesn't come on time, or you are not happy with the product. What you do is that you issue a notice to them and they reply that as per the terms which was mentioned in the website, we are only liable to pay 100 rupees as a limitation of liability. And suppose if you go to consumer court deficiency service, you will prove it. That's a different story. If you are a businessman, if you are a reseller, if you deal with them regularly, you should know किसका meaning क्या है. Simple. So strategy means is all about how you work out your chart in a manner कि मेरा पैसा भी बचे, मेरा काम भी हो जाए, मेरा समय भी ना हो, मेरे बहुत सारे मैटर सॉर्ट आउट भी हो जाए. ये सब तब होगा जब आप फर्स्ट चीज करते हो कस्टमर के साथ, you anticipate ये सब होने वाला. You should anticipate because when you do that, you are in a very good zone. So in short, उसको मैनेजमेंट में यही बोलते हैं कि have your own system set up so that you can work it out. Always be ready with your plan B. I am telling you, plan A आपने जो भी सोचा है, it will definitely go for a success. But you should be ready with your plan B. जैसे मैंने आपको बताया था 138 summary का. The reason is you are totally not aware what is going to happen, but you are assured कि ये सब हो सकता है. Be ready with plan B. Now the moment I say plan B doesn't mean कि you don't have that faith in plan A. See, laws जो होता है ना, law if I can only suggest that you judgment should be read regularly. End of the day, our Indian courts, they go by the precedent laws. Precedent बोले तो judgments आता है. If you are aware of the judgments, I'm pretty much sure your agreement will cover all the aspects, or your drafting or your written statement. If not, then you are creating an issue. I will just close this particular lecture on this one example. Now, what has happened is that there was an arbitration section 11 petition was filed. In that, the pleader, he went to the court and said that we want to appoint an arbitrator. Opposite party, just to save money, he never went to the high court and the arbitrator was appointed. An arbitration proceeding started. Now they came to a lawyer after 2-3 days saying that कि हमने वहाँ पे बोल दिया है written statement file करना है, and they filed a written statement saying that कि ये agreement हो चुका है, ये सब हो चुका है, and then they went to some another lawyer for whatever reasons, and that new lawyer told that this particular arbitration should have never been started because your section 11 itself is invalid. Now just think whether it was right decision or not. If you would have understood the matter, if you would have drawn the plan, what you would have done? You could have directly gone to the High Court and filed a reply. This section 11 has no relevance because it doesn't fall under Arbitration Act. But since he has not done it, since you have already filed a written statement, now you saying that this tribunal has no jurisdiction, you have bypassed that particular part. So your strategy has to be very important. It has to be in every way. Even you taking a date has to come with the strategy. I'm not endorsing the adjournment of matters because I don't believe in that. But suppose if you feel that by doing something on that particular date might hamper my another matter or another thing, that becomes a part of strategy. So make that also as a part of strategy. But for God's sake, don't take adjournments. That will only ruin your cases. Because remember, more adjournment you take as a lawyer, new judgments are coming. If you feel you have a judgment in your favor, get it fast tracked. If you feel not, it doesn't mean you delay, but you can play the strategy of the matter in your favor. And thanks. Okay, I'll just cover the criminal part also. I have some time. I have covered the civil part. Better, basically, मोटा मोटी civil में सब यही होता है. Consumer law and RERA, if they don't follow the Evidence Act, even arbitration they don't follow Evidence Act. So वहाँ पे आपको ये procedure की जरूरत नहीं है. It is being already there in that particular law. Criminal में you need to play very smart. If I am saying civil law में आप ये कर सकते हो, क्रिमिनल में आपको यही करना है बिकॉज क्रिमिनल लॉ इज अनवेरिएबल आई मीन टू सी यू कैन नॉट इवन एंटिसिपेट क्या होने वाला यू इवन डोंट नो व्हाट विल कम there are many cases where you might be shocked to know कि ये भी हुआ है now how to play strategy wise it takes a lot of efforts I will take another कभी कोई lecture ला then I will tell कि how criminal matter should be handled in the manner that you are able to take your matter in a manner where you reach to the conclusion. Criminal, I will tell you one example right now. Now, what has happened is that in one of the cases under Motor Vehicles Act, okay, there was an accident by A of B. B expired. A went to the court and surrendered. Charge sheet was filed. Everything was filed. Now, what has happened is that when the particular cross came, IO said, I don't have any proof that he has killed the person. But yes, I got to know from A, B, and C that he has killed the person. So when the cross was taken of A, B and C, they said कि मुझे लग रहा था इसने मारा है. B ने बोला कि as per the medical report ही उसका एक्सीडेंट 8 बजे हुआ था. He said I came by 7:50 वहाँ पे बहुत भीड़ था तो मैंने देखा हुआ किसी को मरते हुए. That's why I said कि वो मारा हुआ है इसी ने मारा होगा. Third said कि उसका बाइक यही था और ये बाइक का ओनर था तो इसी ने मारा. And basically he was freed. I mean to say there was no strategy even worked out. Assuming also A might have killed him. I'm not sure. A might have killed him, but he's free now. Just see. Suppose if he has not killed him, then also why such investigation was made. So strategy plays a very important role in your business, in your own personal life, in your own studies, everywhere. I'm just ending myself. If you have any questions, please ask me. Thank you.
So in the chat, a participant is asking, I'm a first generation lawyer. Can you give me some tips to excel in my litigation career?
In
Litigation career.
Okay. Litigation career के लिए I will only give the tips that हो सके तो the day when you start your law, you can take the approval of your college and start as an intern under a litigation lawyer. Try to understand the concept how courts work, how litigation works. Summons भेजना भी कोई is not a simple thing. Even getting the summons from the court is a big thing. Start learning summons क्या होता है, warrant क्या होता है. Understand how the court works, understand how the court system works, understand how the arguments are made, and you should attend the courts, go to the court and sit there for 1 hour, just see कि क्या चल रहा है नहीं चल रहा है. ये सब चीजें will make you more comfortable when you by the end you complete the law. Your body will adjust yourself to such a level that this I know everything. But होता कैसा है, we don't give importance to all such. We run after some capital M. I'm not saying it is bad. But running after capital M and you're not understanding how the court works and you suddenly then say कि I want to appear and argue, you might win, you might lose, but the chances of you getting confidence will be on the lower end. So my tip will be that हो सके तो you work under a litigation lawyer, understand the court works. Trust me, give 3 years to the law, litigation, capital M will flow like anything.
Okay, sir. So next question is how to maintain a case diary.
तो बहुत सिंपल है. जैसे आपको कैसे मेंटेन करना है इज इम्पोर्टेंट. जैसे कि मान लीजिए अगर आपका केस आज है, इट डिपेंड्स. अभी तो खैर सॉफ्टवेयर आ गए हैं, यू डोंट हैव टू यूज योर माइंड आल्सो. पहले डायरी लिखा जाता था, ये डेट में ये हुआ, ऐसे हुआ. अभी तो सॉफ्टवेयर है, यू जस्ट पुट द डिटेल्स ऑफ योर मैटर कि क्या होने वाला नहीं होने वाला. बट आई स्टिल यूज द डायरी फॉर माय ओन बेसिक पर्पस. कैसे होता है उसमें मैं ये लिख लेता हूँ कि ये मैटर में ये शॉर्ट में हुआ था, सो आई हैव एन एक्सेल शीट और सॉफ्टवेयर जहाँ पे भी पुट कि ये सब हुआ है, बट हमें जो करना है वी ऑलरेडी पुट इन दैट पर्टिकुलर केस डायरी कि ये अभी हमें करना है, एंड बिफोर दैट 1 वीक बिफोर वी ट्राई टू अंडरस्टैंड कि ये कैसे करना है क्या नहीं करना। सो केस डायरी में वो सब आना चाहिए, लास्ट डेट, नेक्स्ट डेट, आपका मैटर्स, जज का नाम तो आप प्लीज फॉर गॉड सेक लिखिए, बिकॉज एक तो आपके हाथ से जज का नाम लिखना, दैट इटसेल्फ गिव यू कॉन्फिडेंस कि मुझे किसके सामने बात कर। डोंट बी सरप्राइज्ड।
Sir, if the divorce has
Okay.
been granted to the couple on grounds of desertion and cruelty by the wife,
Mm-hmm.
then what should be the strategy for claiming child custody under Section 26 of the Hindu Marriage Act for the wife?
Okay. So by the time you got the divorce, whether it was a contested divorce, Shivam, right? Hello.
Yes, I was not able to mute. Yes,
Uh,
it was a contested divorce.
ठीक है, and I don't know about the matter, but as a wife, I'm pretty much sure that you might have raised this issue that the child has to be with mother. I don't know why. If that was not your case, then I'm surprised because child has to be with the mother, assuming he is less than 5 years of age.
The child is 10, 11 years old.
And then see, basically it's like this. She can go to the court, she can file the claim that I want the custody of the child. But since she is 11 or he is 11, I'm pretty much sure the court will ask him. So strategy
Yes, sir.
wise, you could have used this strategy when your case of divorce was going on, actually.
Right, sir.
But right now everything has happened, so definitely you have to go to the fresh case to get the custody.
Yes, so
I think the judge will call the child and will ask him.
okay, I will find the fresh appeal only, sir, in
Go
this
for it.
case.
Yeah, we
Yes,
should.
sir.
You see, appeal, I am not sure because I have not read. If you feel there is a merit in your matter, then file an appeal. But then try to sort out the problem.
Sure, sure. Thank you so much, sir. Thank you.
Okay, so next query is how to draft prayers. Any tips for drafting successful prayers?
Okay, ऐसा होता है कि prayer is the last para we should do it in your suit or complaint. But that last para starts from the first para. Because if you don't make your mind, what are my prayers? You cannot even draft your suit or pleading or your complaint anything. Because your pleading is drafted so that suits the prayer. ऐसा नहीं कि आपने pleading लिख दिया फिर prayer लिखा. No, it is the last para in any case. But that last para starts with the first para. So think what you want and then accordingly draft your suit, your complaint, your whatever. So your last is first when it comes to drafting. आपको क्या चाहिए उसके हिसाब से केस को बनाना पड़ता है. It should not be the last. It should be the first in your mind and then put para as the last. और टिप्स बोले तो अगर आपका रिकवरी है, ensure that your pleadings are convert, claim for the money, claim for the interest, claim for the cost of the suit, claim for the damages if there is a part of the agreement. अगर आपका 138 है, then it's a very normal thing that you ask for the summons issues and double the check amount. What I'm trying to say that ensure that your prayer should not be such which is not the part of the pleadings. If you don't plead, you will not get the prayer or the relief.
Okay, so there's one more question. How to ensure that my client gets the best in and out of the court settlement?
Well, it's an art actually. Again, I'm telling you, it's all about strategy. Who comes first? Well, there's a big debate going on nowadays. Who comes first? It means that is the inferior party. Let's change that perception. Whoever comes first, if you are able to sort out the matter, that is very good for both the parties. Now, what to take in the settlement or not, it depends. If it is a family matter, it depends what are their choices. So, it cannot be discussed, everywhere. Suppose if it is a business matters, आपको कितना नुकसान हुआ है, कितना गया है, आपको कितना क्लेम करना है. बट अगेन यू कैनॉट क्लेम एवरीथिंग बिकॉज आई एम प्रीटी मच श्योर कि बाजू वाला पार्टी का सेटलमेंट कर रहा है, सो ही इज कमिंग विद एन एक्सपेक्टेशन कि आप कुछ कम करोगे. अगर आप कुछ कम कर ही नहीं हो तो वो यही बोलेगा नहीं, काम कर, पूरा मैटर लड़ ले, जो प्रेयर आएगा मैं दे दूंगा. सो नाउ यू आर इन द ड्राइवर सीट कि हाँ मैं क्या करूँ, 3 साल प्रेयर करूँ, 3 साल ऑर्डर लो, फिर रहा हूँ या कुछ कम करके ले लूँ. सो यू नीड टू, जहाँ पे कमर्शियल आ जाता है, यू नीड टू प्ले स्मार्ट कि बाजू वाला पार्टी कैसा है, व्हाट इज स्ट्रेंथ is there any issues faced by him. I will just cite one example on this part. It is very important. 4-5 years back there was a matter which was going on. There was a case filed for some 22 lakhs. The person who filed the case, he wanted 45 lakhs. The opposite party told him that I'll pay you 20 lakhs in 2 years, and he agreed. He came with a settlement check also, but this man said नहीं, मैं तो पूरा 45 लूंगा, law मेरे साथ है. So he fought for 2 years, so that by the time 2 years completed, this he got the NCLT order saying that the company is getting liquidated. So he went to the person saying that मुझे 20 लाख भी चलेगा. बोले अरे नहीं रे भाई, ये भी 20 लाख तो छोड़, भी 1 लाख भी नहीं दे सकता. So you should know आप उस टाइम का सिचुएशन, you should be aware of it. Don't try to claim so big, but try to be very reasonable and close the matter.
Okay, so the next question is, many a times the client keeps on altering the facts or is dishonest. So, what facts should we consider?
Well, make a habit of putting all the facts in a date-wise synopsis. If there is no date-wise, at least put synopsis. The reason I have been telling you that, read judgments, read books, the reason is, see, even, sitting with the client, even discussing with the client, it requires your sharp mind. Because if you think that your client is saying everything which is true, don't go with that mindset. He will tell you A, B, C, D, something out of the context. Now you have to use your mind. What he's saying is relevant for law or not. Now, he might be saying everything to you. If possible, make the synopsis, make event, or tell the client कि आप मुझे brief में event लिख के दो. Go through the event. Trust me, if you have a good absorbing mind or mindset, if you are aware of the judgments, you will catch what is right, what is not correct. Then if you feel what is incorrect, ask him openly. आपने जो ये बताया है ये हुआ था या नहीं हुआ था. So there are two persons. एक हुआ था but I cannot prove it, ये नहीं हुआ था. जो बोलता है वो नहीं हुआ था, आप मान के चलो कि आपको अच्छा क्लाइंट मिल गया. एक वो बोलता है कि नहीं नहीं ये हुआ था but I cannot prove it. Then law comes into picture. Then your mindset comes into picture, whether what he's saying has even relevance or not. Because you cannot put everything what he says in law. Because the moment you approach the court, you need to be very specific what you want to ask, what you can claim, what you have to produce as an evidence in the court. कभी कभी ज्यादा proof देना भी problem है और कम proof देना भी problem है. So you need to strike the balance.
Sir, registration form, there is one question. What is formal decorum that one needs to follow in the courts?
Okay. If you're a lawyer, go dress up as a lawyer. Avoid any other dress which is not required to be wear. Go there. If you are an intern, go there. Sit quietly. आप एक अच्छे पोस्टर में बैठो. Legs को अच्छे से रखो. Don't try to drink water because everyone knows what happens when you drink water in the courts. LinkedIn सबके पास है. Don't talk. You are in the court not to talk but to learn. If you are able to learn, don't talk, just see what is going in the court. Mobile ko silent rakho. Assuming also that something has happened to you which was not as per the ethics of the court, and if the judge calls you, go there. If you feel you have made, say sorry, accept it. Don't try to plead or bargain because there is no relevance to it. If you feel you have not done anything wrong, and if you feel that you arguing with the judge will make more words, say sorry. Saying sorry is not a very big deal. Say sorry and just close it. If you feel something has very bad happened to you in the thing, then you can take the permission of the registrar, meet the judge, and tell him the story. Simple. Keep it very simple. If you're a lawyer, go in a very attire dress. If you're in high court, please wear the gown. If you are in a district court, don't wear. See, that's my personal view. I am not against anyone. Please wear the band. For me, tie doesn't suit it. Wear the proper attire dress. Go with the file. Don't appear before the court without file, for God's sake. I agree that nowadays we have tablets and everything. Very good. If you are very well acquainted with the use of the tablet, go for it. But at least be aware of the facts of the case. ऐसा नहीं कि मान लीजिए अगर आपको सिर्फ डेट लेने के लिए भेजा है एट द स्टार्ट ऑफ योर करियर, ऐसा नहीं कि आपको सिर्फ डेट लेना है तो आपको मैटर ही नहीं मालूम है. एटलीस्ट बी अवेयर ऑफ द मैटर. इवन इफ यू वांट टू टेक द डेट, इफ द जज आस्क्स यू कि मैटर क्या है, यू शुड बी इन ए पोजीशन टू टेल कि ये मैटर है, आई वांट द डेट. ट्रस्ट मी, दे विल अप्रिशिएट. आई हैव सीन मैनी पीपल कि वो डेट लेने आते हैं, एप्लीकेशन दे देते हैं, दे आर नॉट अवेयर ऑफ द मैटर. व्हेन द जज आस्क्स क्या है, वो बोलते मुझे मालूम ही नहीं. दैट गिव्स अ बैड इंप्रेशन. So at the end, image plays a very important role as a lawyer or anywhere, but I'm talking as a lawyer. Please try to create the image that you are not just a lawyer. You are a lawyer, who want to learn, who want to make something difference in the legal society, and go for it.
The participant is wanting to ask that suppose an advocate, doesn't really take any steps, but just by mere appearance, will it amount to appearance of the advocate?
Now, what do you mean by mere appearance? मतलब ऐसा तो
That's
नहीं
what
कि
the
आप
participant is not unmuting. Yeah.
नहीं नहीं कोई नहीं, ऐसा तो नहीं कि आप दरवाजे पे खड़े हो और साइड से देख रहे हो और फिर पीछे जा रहे हो. सो दैट इज नॉट mere appearance, that is hide and seek. So that is no value. But I don't know what was the logic, but what I can understand is like this, that he goes to the court, he or she, he doesn't appear before the court, but he appears before the registrar or the clerk and say that कि मैं आ गया हूँ, मैं आता हूँ, and then he or she doesn't come till 5 o'clock, and then he sees कि क्या हुआ मैटर में, कुछ हुआ नहीं है, then he will go without informing. ऐसे अगर वैसा है by any chance, then it is not a good practice. But then it depends कि कौन कैसे practice करता है.
Okay, sir. We'll move on to the next question. What if one gives a misstatement in front of the judge?
Who
So
as a,
how can
who as a
a
lawyer?
lawyer?
First of all, तो I don't know why we should give such misstatement, but ये होता है. When you are arguing the matter, it happens. Now misstatement हो सके तो आप avoid करो. That's what I'm saying. Now the day when you feel that you are appearing before the court, understand the facts, make a synopsis of the event, and just avoid misstatement. Because end of the day, you ex parte proceeding है और अगर आपने misstatement दिया, it might get off. किसी को mind में नहीं आएगा. But if there's a lawyer opposite to you, he will catch hold you and avoid it. I mean to say, see, misstatement has no place in law. आज नहीं तो कल वो पकड़ा जाएगा. And you by doing that and getting an order is an appealable matter. और appeal में वो हार जाएगा, then you are not doing any good justice for your client also. So try to avoid misstatement. Ex parte है तो misstatement की जरूरत ही नहीं है.
But sir, in case misstatement दे दिया and later on you realize there's no going back, right?
Sorry बोल दो और apology करके undertaking दे दो if the court says. If the court doesn't say anything, apologize and close it. If suppose if you file a false affidavit, then trust me, it is a big crime. So just making a oral statement, misstatement can be, saying okay, fair enough. But you giving in writing a misstatement, it will lead to a very bad result. So avoid it.
Okay, sir. So, sir, I think we are done with the query. Thank you so much for your immense contribution to our platform.
Thank you.